Hello, today I'd like to talk a bit about alternative dispute resolution. A lot of times when we think about a dispute, we think about immediately going to court. However, millions of disputes are handled every day using other methods of dispute resolution, and very few cases end up in court. Even back in the day of Abraham Lincoln, he gave advice to attorneys. And his advice to attorneys was to discourage litigation. And there's some very good reasons for that. Now, there are lots of ways to handle disputes, and there are many creative ways. 4 ways that we can focus on that are major categories are, of course, negotiation, mediation, arbitration, and litigation. These go from the least expensive to the most expensive. Negotiation, 2 parties negotiate, sometimes through their attorneys, sometimes not. Litigation, going to court, can be extremely expensive. In between, we've got mediation and arbitration, which I want to do some comparison with today. First of all, though, let's talk about why arbitration is a good thing as compared to litigation. If you go through the judicial system, you're going to have some high financial costs usually. You're going to end up with attorney's fees, court costs, time costs, and so forth. So that is a negative of litigation. It may take years to get your day in court. You may spend thousands, if not hundreds of thousands, on your attorney. Instead, you could consider going through arbitration, which would hopefully be quicker and cheaper. In addition, arbitration has this privacy factor. Keep in mind that in most cases, what you are doing in the court is public, and so the public is allowed to attend the hearings in most cases, not all, and also the public can come to the courthouse and look at the records. So this privacy factor can be a real important thing to a business. They may prefer to have arbitration where the procedure is private. The records are not kept at the courthouse and opened up to the world, and so that can be a positive. Also, formality can be kind of interesting. In litigation, there's quite a bit of formality. We've talked some about procedural rules in litigation, and there's lots of formality involved there. Arbitration is less formal. Another nice thing about arbitration as opposed to litigation is, in arbitration, you get to pick the decision maker. In litigation, you don't usually get to pick your judge. You may make some efforts to schedule your case in front of a judge that you think would be more favorable to you, but really you have a limited choice and you may have no options for controlling that. Whereas in arbitration, you can select your decision maker, or the parties can select, based on the decision maker's fairness and expertise and so forth. And so that can be a very positive thing. You can also choose in arbitration where you conduct the arbitration. And sometimes if the parties are, one in California and one in Arkansas, it's very inconvenient for them to meet at either court for litigation and maybe make repeated trips to litigate. But arbitration could be done using possibly a Skype method or an online method, or maybe choose to meet in the middle as opposed to just the court that happens to have jurisdiction. So those are some positive things about arbitration as opposed to litigation. There are 2 types of arbitration. One is called voluntary or contract-based. And this is a wise thing for many businesses to include in their contracts. It's basically where the contract says that the parties waive their right to a jury trial, which is important because that's a constitutionally guaranteed right. So you want that waiver in writing. And they also agree that they will arbitrate. And the contract can describe how the arbitrators will be chosen, whether there will be 1 arbitrator or 3 arbitrators, and those types of things. And so this way, there's an agreement about how things will be settled before any dispute arises. And this keeps everybody out of court in a lot of cases. And so that can be a good thing. Some parties don't want to plan that way or don't want to include that type of thing in a contract, or sometimes there is no contract. You can also have contract or voluntary contract-based arbitration after the dispute arises if both parties agree, and that's the trick. It's better to go ahead and include the clause in your contract, but if you cannot, then you and the other party can agree after the dispute arises. If both of you are willing, you can still go to arbitration. Now, there's another type called statutorily mandated arbitration. This is where the parties have not written a contract that agrees to go to arbitration, but instead the court says you have to do arbitration, and that's a very different thing than this voluntary. So keep these two separated. So an example might be if you go to court and say, we want a divorce, and the court says, well, the statute in our whatever jurisdiction you're in requires that you go through arbitration instead before the court will hear your case. And that the parties may not like that, but that may be required. So remember the difference in these two, and we'll talk about that a little more. All right, differences, comparing the two types. For voluntary or contract-based arbitration, it's between the parties and it's private. Keeps it out of the newspapers. There's limited discovery, no subpoena power, no rules of evidence. And very, very important is this one right here, the binding award. Arbitrator makes a decision and that award is binding, and there's no going to court. There are very limited grounds for going to court. The limited grounds could be, if the arbitrator committed some sort of fraud or extremely improper conduct. But just a mistake by the arbitrator probably won't get you in court. So binding award is critical. The whole purpose of arbitration is to save time and money. And if we start saying, well, you have a contract that says you'll arbitrate, but if you're not happy, then you can go to court, it defeats the purpose of the arbitration clause in the contract. Another nice thing, as I've mentioned, is the arbitrator can have expertise. If this is a dispute about construction of a building, for example, you could pick an arbitrator who knows about construction practice, knows about engineering, architecture, or whatever the case may be, and instead of having a judge or a jury make decisions when the judge and jury may have no expertise in the area that you're talking about or disputing. There's also usually lower cost and lower stress. Now, statutory mandated arbitration is a different bird. Let me talk about why. That's a court-mandated arbitration. You didn't choose this, and so it's very public. There's full discovery, subpoena power, rules of evidence, and the thing is, it's not binding unless the parties choose not to appeal. But it can be appealed to court, so it's not really always going to save you from having to go to court. It may just add another step in the process of going to court. So the appeal rights are preserved. Now, why is that? Why do you get appeal rights in the statutory mandated and not the contract? Well, in the contract one, you have agreed to give up your rights to go to court. Remember that your right to go to court is guaranteed by the U.S. Constitution. And you can waive that, but you need to waive it understanding it and waive it in writing. If you don't do that, if a court's making you go through arbitration and give up your jury trial, then they really can't do that. It would be unconstitutional. So you still have the right to have your day in court if you're not happy with the statutorily mandated right or arbitration. Also, the problem with the statutory arbitration is generally the arbitrator is somebody appointed by the court, like an attorney who has little expertise in the subject matter. And the cost can be greater because it may just add another layer to the litigation process, and it may be even more stress than litigation. So very different things. Now, there are a few disadvantages of contract-based arbitration. Overall, most people, I think, feel that this type of arbitration has advantages, and that's why so many businesses do put arbitration clauses in their contract requiring that arbitration be done instead of litigation. But there is a limited right to appeal. Oops, excuse me. Let me go backwards here. And Oh, sorry, I somehow made a typo here. Pardon me. Limited right to appeal and a lack of full discovery and disclosure requirements. Now that can be a problem, the right to appeal, if you really feel that the arbitrator got the law wrong. You probably are stuck anyway, and that's too bad. So that can be a disadvantage. Hopefully you'll have good, knowledgeable arbitrators and generally that won't happen. But if it does happen, you're probably pretty stuck unless the arbitrator committed some sort of fraud. There are no formal rules of evidence. That can be good or bad. Some things may come into the evidence that wouldn't have come in a trial. Another problem is that these agreements that you will arbitrate are often buried in the contract. And there are lots of cases where we click, for example, an online contract and don't read it at all, or sign something at the bank and don't really read it that includes an arbitration clause. And that's kind of unfortunate if they're buried in the contract and you don't even know it's there. Arbitrators can have unknown biases just like judges or juries. Some believe that arbitrators tend to compromise. So if I think you owe me $200,000, you think you owe me $0, an arbitrator, according to some people, may just cut it down the middle and give me $100,000. And that's kind of, maybe not necessarily the best thing. Another thing about arbitration is it doesn't create precedent. So arbitrators don't write opinions like judges, which means they do not create common law. All they do is write an award, which could be as simple as I award party X $1 million. And they don't usually have to give a whole lot of reasons for that. And that is a downside because then this valuable precedent or common law is not created. And so litigation is valuable in the sense that it does create this common law. But these are still generally contract-based arbitration is considered valuable. And the Federal Arbitration Act backs that up. And it governs any contract dealing with interstate commerce. And it encourages disputing businesses to utilize arbitration. And courts are rigorously to enforce arbitration agreements. And case after case will show that courts generally do that. All right, thank you very much, and I hope this has been helpful.